Corpus.
Hello everyone, a very warm welcome to you all. This is Monisha from Corpbiz, and in this video we are going to learn about patent registration process in India. Let's take a look on the overview of patent registration. Patent registration provides a statutory right to the inventor by the government for his or her invention, which is either a new process or a new product. The registered patent helps the inventor to prevent the third party without authorization of making or manufacturing, using, offering for sale, selling, importing, distributing, and licensing. So what are the patentable subject matters? The below which we are discussing will help you in determining that the invention is patentable or not, which are novelty, inventiveness, inventive steps, utility application, must not fall under section 3 and section 4. In India, the patents are administered by the Patents Act 1970 and Patents Rule 1972. However, inventions must not be published in India or outside India, in prior knowledge or already in use in public within India and claimed before in any specification in India. What are the benefits of patent registration? So the benefits includes that it grants right to the inventor. Registered patent keeps the opponent away as the inventor has all the rights owned by him or her. Good market reputation is built. Patent rights enable the inventor to get a noticeable market status and improve his portfolio by uncovering the invention publicly. It then helps in building up a good relationship with consumers and competitors that ultimately add to his revenue. The patent registration enhances the business interest. Patent registration enhances the business interest and enables the registered patent holder to receive a premium for the invention. Public disclosure. Patent rights allow public disclosure that helps the inventor in building up his portfolio along with the increasing the funds, market value, and business partners. Sharing information that pertains to the invention publicly will demonstrate the inventor's specialization and good command over technical subject matter. All these facts benefits the owner by attracting leading and high-end investors, shareholders, business partners, and consumers. The patent registration also provides legal status to the registered patent holders. It provides legal status. It is reasonable to license them. Fundraising. If a patent holder ready to sell or license the patent that he or she possesses, it helps in simplifying the process of raising the funds. It enhances the credibility. The credibility of the inventor will get enhanced after the patent registration is done. Privileges for return on investments. Sometimes the owner finds that his invention is not bringing good outcomes for him and therefore wants to hand it over to any other deserving or successful person. Once obtained, the patent rights allow him to learn or earn good amount of returns on investment. That is, returns on his investment by commercializing the invention. It also leads to the advantages in the longer run. The selling of the invention will result in various advantages to the inventor. It only helps in getting a royalty of 5%, but it is highly advantageous to the investors who have the idea but don't have the appropriate money to bring the discovery to the market themselves. It prohibits usage of registered inventions. Registered patents prohibits others from using patent's creativity without the patentee's permission. Also, in case of violation, it helps in suing the third party. It also grants exclusive access from early filing. Patent registration begins bestowing the investors with the benefits right from the first step, that is the time of filing for the patent. The applicant gets the security and the surety that no other person or company could claim the ideas similar to his invention as soon as he files the provisional patent application. This registration also grants the liberty to make changes. The patent law entitles the owner to use his ideas in any way for the permitted period. It means that the owner owns full freedom to utilize, sell, or even modify the original invention and to prevent others from making profits from the same ideas without his consent. So, what are the essential ingredients of complete specification under patent registration? The essential ingredients includes title and preamble, prior art, loopholes in the prior art, solution to drawbacks, summary of the invention, statement of invention, particulars of inventions, particulars regarding drawings, examples, claims, etc. Now coming to what are the documents that are required for patent registration. For patent registration, the below mentioned forms and documents are required. For Form 1, that is the application for grant of patent, identity proof of the inventor and the assignee, address proof of the inventor and the assignee, contact details, information corresponding to prior patent application relating to current invention which you or any authorized entity has filed, some declarations among other information. For Form 2, that is provisional or complete specification, it is used to furnish your patent specification. It may be provisional or complete patent specification depending on the type of the patent application you are filing. For Form 3, that is statement and undertaking under Section 8, the particulars of assignments, details of foreign filing. For Form 5, which is a declaration as to inventorship, this application is used to declare the inventors of the current patent application. For technical information, background of the invention, disclosure of the need of the invention, summary of the invention, description of how the invention works. For Form 18, which is the request for examination. For Form 19, which is the request for early publication. Form 26, disclosure of power of authority if assigned to the patent agent. Then for request for publication, this is optional and is provided in Form 9 if the express publication is required. Other details includes disclosure of claims and abstracts, requisite statutory fees in the form of check or DD, proof of the right to file the form of patent. The proof of right can either be an endorsement at the end of the application or a separate agreement attached with the patent application. MSME or startup certificate, provisional specifications. If complete specifications are not available, priority documents must be filed in the following cases like convention application under Paris Convention, PCT national phase application wherein requirements of Rule 17(1)(a) or B of has not been fulfilled. If the application pertains to a biological material obtained from India, the applicant is required to submit the permission from the National Biodiversity Authority any time before the grant of patent. The application form should also indicate clearly the source of geographical origin of any biological material used in the specification. All patent applications must bear the signature of the applicant or authorized person or patent attorney along with the name and date. Now coming to the procedure for patent registration. The process of patent registration involves various steps which can be enumerated like step 1 includes engaging a professional. Before you proceed with the filing of patent application, you need to decide if you will be taking any help of patent professional or undertake the patent process itself. Considering the number of deadlines, it is recommended that you hire a professional who has experience in the world of patents. If you decide to take the help of professional, make sure that you sign an NDA, which is a non-disclosure agreement with the patent professional before revealing about your invention. Step 2 includes patentability search. The very first step for patent registration is the patentability search. Patentable search determines the novelty, inventiveness, industrial application, and enabling of the invention. After patentable search, an applicant needs to create a user ID and password for applying online. Step 3 includes drafting the patent application. After a patentable search, if the invention is patentable, an applicant has to draft an application which includes the description of the invention. Once a patent application is drafted, the very first step is to file the patent application. Step 4 includes patent filing application. The next step is filing the application. An application must contain specifications of the invention and other required and related details of the invention. An applicant can file both provisional and complete application for their invention to get a patent registration. Step 5 includes publication of application. Once the application is filed, it goes to the Indian Patent Office. Simultaneously, the Indian Patent Office publishes the patent application in the official patent journal. Along with the same, the patent application comes in the public domain after the Patent Office publishes it. Every application is published in the official journal after 18th month period from the date of filing the application or the date of priority of application, whichever is earlier. There is a provision for early publication of an Indian patent application by filing a formal request. The early publication rule does not apply if secrecy directions are imposed under Section 35 of the Act, application has been abandoned under Section 9, subsection 1 of the Act, the applicant has withdrawn his application 3 months prior to the expiry of said prescribed period of 18 months. Step 6 includes examination of the application. After publication, the next is the examination of patent application. Unlike the publication of the application, the examination does not happen automatically by the way of filing the Indian patent application. For examination, the applicant has to request for examining their patent application. It helps in determining whether the invention meets the statutory requirements for patentability or not. The examiner examines the application considering the prior art information of the invention. Step 7 includes objection by the examiner. The examiner can raise the objections while examining the application. The examiner scrutinizes the application following the Patent Act. Based on the information mentioned in the application, the examiner will issue an examination report to the applicant. The examiner will state all the objections related to the application. Step 8 includes office action response. Once the examiner issues the examination report, the applicant has to successfully revert on the objections raised by the examiner to receive a patent grant. The applicant has to respond to examination reports, appearing for hearing, etc. The maximum duration given to respond is of 6 months from the issuing date of first examination report. However, this duration can be extended for a period of another 3 months by filing a request to the IPO. Step 9 includes grant of patent registration. Once the application overcomes all the objections raised by the examiner, the Patent Office will grant a patent to the applicant. Once the patent is granted, the IPO publishes it in the Patent Gazette. So, what are the penalties for unauthorized claims to patent rights? Section 120 of the Patent Act penalizes the cases of unauthorized claims to patent rights. Thus, any individual or entity who falsely represents any article sold by him to be patented in India or falsely represents the subject of an application for a patent in India is punished with a fine which may extend to 1 lakh rupees. What is a complete patent application? Complete patent application is an exclusive legal right given to an inventor. It gives him or her legal authority to exclude others from making, using, selling, and offering for selling or importing a particular invention. This right remains valid for 20 years from the date of filing. The holder of the patent is entitled to sue any person who violates the patent and chooses to sell, grant, or license the patent. Coming to the fact for what is not patentable in India. The invention is not patentable if anything is a mere discovery and does not have any inventive steps. Frivolous, obvious, contrary to law, injurious to public health, and inventions relating to atomic energy. A mere arrangement or rearrangement or duplication of known devices, and anything that does not have any utility. A method of agriculture or horticulture. Anything comes under Section 3 or Section 4 of Patent Act 1970. New Indian patent rules offers benefits to startups and small entities. India's latest chain of amendments to its patent rules are expected to hugely benefit startups and small entities requesting patent protection for their inventions. With these amendments, overall filing and registration fees for startup and small entities have been considerably reduced. While the fees applicable for small entities have been concentrated outright, startup can retain their startup position for up to 10 years, thus permitting them the benefit of favorable fees for an absolute extended period from what was earlier available. Earlier this year, the famous scheme for facilitating startups' intellectual property protection that was firstly launched as a pilot project to help startups in increasing and protecting their intellectual property has been extended for an additional period of 3 years from April 1, 2020 to March 31, 2023. Corpus procedure for patent registration. Kindly utilize the steps as we discussed above to integrate legally and securely a patent registration and get the benefits in the form of better quality and long-lasting inventions. Our Corpbiz experts will be at your disposal for assisting you with guidance concerning patent registration and its compliance for the smooth functioning of your inventions. Corpus professionals will assist you in planning seamlessly at the least cost, confirming the successful conclusion of the process. It is advisable that an attorney with IPR experience must be appointed to overcome many of the potential pitfalls that creep around within patent registration and to understand the requirement in detail. The elementary information would be mandatory from your side to start the process. The attorney will begin working on your request once all the information is provided. So why you should choose Corpbiz? Corpbiz is one of the platforms which coordinate to fulfill all your legal and financial requirements and connect you to the consistent professionals. Yes, our clients are pleased with our legal service. Because of our focus on simplifying legal requirements, they have consistently regarded us highly and providing regular updates. Our clients can also track all the time's progress on our platform. If you have any questions about the patent registration process, our experienced representatives are just a phone call away. Corpus will ensure that your communication with the professionals is charming and seamless. Purchase a plan today for expert assistance, add queries regarding patent registration, provide the documents, prepare the application for the patent registration, complete all admissible criteria for preliminary screening, complete all the procedural actions, get your patent registration done at your doorstep. For more concerns or questions on working of patent registration process in India, kindly email us at info@corpbizadvisors.com or call 98703 10368. Please like, share and do subscribe. Thank you.